Breaking news out of the United States Supreme Court. The lawyers in the case of Gray versus Jennings have filed a letter asking essentially for the U.S. Supreme Court to expedite the consideration of their case dealing with the arms ban out of the state of Delaware and the preliminary injunction standards that go along with it, and to essentially consolidate it, which what I am predicting will be the January 10th conference dealing with Ocean State Tactical versus Rhode Island and the Snope versus Brown AR-15 ban case out of Maryland. So let's break down what this letter means and to give you some critical dates for you to circle on your calendar for the year of our Lord, 2025, the month of January. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a nominee for the 2025 Gundies Awards in the category of Top Voices of the 2A, Top Voices of the Second Amendment. If you haven't voted for the Gundies, this is your last chance. I think today is the last day. December 17th is the last day to vote for the Gundies. If you're going to vote for Mark Smith, Four Boxes Diner in the category of the Top Voices of the Second Amendment for the event in Las Vegas at the end of January 2025. All right, folks, so we're going to connect some dots here. Pull out your calendar. Get out your little Palm Pilot. Get out your little BlackBerry. Get out your cell phone, your iPhone, whatever it is that you all keep dates on, your wall calendar, and get ready to write some stuff down because I'm going to give you the key dates that you need to pay attention to and look out for. But before I get there, I want to talk about a letter that was just filed to the U.S. Supreme Court by the law firm on behalf of the petitioners in the Gray versus Jennings case. Now, we've gone over the Gray versus Jennings case before. This is the case that arose out of the U.S. Court of Appeals for the Third Circuit based in Delaware, Pennsylvania, New Jersey. Three-judge panel ruled against the Second Amendment petitioners who had sought an injunction, a preliminary injunction against the quote-unquote assault weapon ban enacted by the state of Delaware. Gray versus Jennings. Now, this was denied by the Third Circuit, applying what I consider to be the wrong standard for deciding preliminary injunction cases because of the way they said that the Second Amendment plaintiffs have to show a lot more than just that they're likely to prevail on the merits of a Second Amendment claim, and I think that's wrong, and I think that's inconsistent with the rest of the country. Nevertheless, that's the issue presented in Gray versus Jennings. Now, what's just happened here is the lawyers for Gray versus Jennings recognizing the machinations going on with the United States Supreme Court in the two other cases that sort of speak to the same issue, AR-15 bans, magazine bans. Ultimately, these are all arms ban cases governed by Heller. Those cases, as you know, are the Snope versus Brown case out of the state of Maryland through the U.S. Court of Appeals for the Fourth Circuit. And, of course, the Ocean State Tactical, and somebody let me know repeatedly, and this is good. I'm glad if I make a mistake, let me know. It's not Ocean Tactical, it's Ocean State Tactical. So I apologize to our friends over there at Ocean State Tactical. Ocean State Tactical versus Rhode Island is the name of that other case dealing with the magazine ban of the state of Rhode Island. So now you basically have the AR-15 ban out of Maryland in front of the Supreme Court. You've got the magazine ban out of Rhode Island in front of the Supreme Court. And now you've got Gray versus Jennings in front of the Supreme Court, all pending cert petitions. Granted, what that means is that a cert petition is pending. If it's granted, it means the Supreme Court will hear the case on the merits, or it could be denied, or it could be shelved, pending the outcome of another case. But as you know, the Supreme Court has rescheduled basically the conference in the Snope case dealing with AR-15 bans and in the Ocean State Tactical case dealing with magazine bans. Now, the lawyers for Gray versus Jennings clearly want to be part of that gestalt, which is kind of what I predicted, that there was going to be a gestalt of these three arms ban-related cases. And here's what the lawyers wrote to the U.S. Supreme Court just now. In accordance with this court's Rule 15.5, the Second Amendment petitioners hereby waive the 14-day waiting period for distribution of the petition for cert and request that the petition for cert be distributed to the U.S. Supreme Court justices on December 24th, 2024, for the conference on January 10th, 2025. The Second Amendment petitioners will file their reply brief on December 20th, 2024, signed by the lawyers of the law firm Cooper and Kirk, which are the lawyers for the Second Amendment, plaintiffs in this case, the petitioners of Gray in the Gray versus Jennings case. Okay, so now, with that set up, what does all this mean? I'm going to make this real simple for you. I want you to circle 3 dates on your calendars, on your Palm Pilot, on your iPhone, on your iPad, whatever it is you use. Ready? The first date is January 10th, 2025. January 10th, 2025. Then I want you to circle the date of January 17th, 2025. And then I want you to circle the date of January 24th, 2025. These are the 3 dates that is a version of our Election Day 2024, if you're in the Second Amendment community. It is on these 3 dates that the United States Supreme Court will be holding their final conferences, barring something extraordinary, the final conferences for the 2024-2025 Supreme Court term. Why does that matter? As you know, the conferences are the meetings with just the 9 justices to discuss whether or not to grant cert in a particular case. This is where they sit down, they look at every case, and they decide whether or not to grant cert or deny cert or potentially do something different. It is on these 3 dates that this is my prediction. I'm pretty good at this. Here's my prediction. I suspect that what will happen is the 3 Second Amendment cases of Snope, of Ocean State Tactical, and of Gray versus Jennings will be conferenced on January 10th by the U.S. Supreme Court. And what we're going to want out of that is this. We're going to want to find out a day or 2 after that January 10th conference that one or more or all of those cases that I just mentioned will be relisted. Will be relisted. Not rescheduled, but relisted, which means it will be reconsidered at the next conference on January 17th. And then what we're going to want is to light candles and pray to our lords, pray to the Lord, pray to whomever your God is, that we find out on or about January 18th, 19th, or 20th that cert has been granted in one or more of those Second Amendment cases of Snope, Ocean State Tactical, or Gray versus Jennings. That is the schedule that we want. Now, it's possible that we may not get a decision on that until after the January 24th conference, which means we would know by January 25th, 26th, 27th or so. But if we find ourselves January 26th or January 27th of 2025, and there's been no cert granted in any of these Second Amendment cases, that will be, in my opinion, bad news, bad news. Okay? I don't think that's going to happen. I got my fingers crossed. I'm cautiously optimistic. But I want you to understand what to expect, and I want you to have the real dates. And for other YouTubers and others who watch this channel, those are the dates you need to understand and talk about on your respective channels. Okay? So get that right. That's what you need to do. If you need to look it up, you just have to type in calendars and order lists on the U.S. Supreme Court docket. You can track this calendar down and figure it out. It's not that hard. It's actually color-coded. Okay, so the last thing I want to mention is just to help you out, because I know a lot of you like the inside Supreme Court geeky stuff. I just want to tell you the process that's about to go, which is about to be undertaken by the court involving these 3 Second Amendment cases, just because I think it might be interesting to some of you who really like this inside baseball Supreme Court stuff. A case first has to be fully briefed, and that's what this letter from the law firm of Cooper, Kirk, and Gray versus Jennings is about. They're telling the Supreme Court that we're going to submit our reply brief in Gray versus Jennings on December 20th, which means that at that moment, that case will be fully briefed. Now, the Snope case, the Ocean State Tactical case, and as of December 20th, the Gray versus Jennings case will be fully briefed. Now, what a case means, if it's fully briefed, is that all the briefs, all the legal documents, all the materials that the parties want the court to consider to decide whether or not to grant cert, which means, of course, if they grant cert, they're going to hear the case on the merits, which is what we want with the Second Amendment case. All of them is done. It's fully submitted. After a case is fully submitted, all those materials are distributed in a package to all the justices. to be distributed. That's what it is. You got fully briefed first, and it's fully distributed to the court and the justices. It is being distributed for all the justices to review the briefs in anticipation of a conference. A conference is then scheduled. At that conference, the judges will have already read the lawyer's papers, and they will go to the conference, and they will vote whether or not to grant cert or not. If they are going to deny cert, they will deny cert. And the way you get a case granted cert is you have to have four or more justices vote to hear a case. That's what it takes to hear a case. If you don't have 4 justices to hear the case, that vote to hear the case is denied cert, which means it's rejected, and thousands of cases are rejected every year. They only take 60 to 70 cases a year and decide them on the merits now. So again, that is what happens at the conference. Most cases are denied cert. Some, however, are granted cert. And then I want to talk to you, this is inside baseball, but I know a lot of you like to hear this, so I'm going to give it to you. I'm going to give you the information so you get it right from the horse's mouth, if you will. If the Supreme Court is going to grant cert in the case, and listen carefully, Chief Justice John Roberts has a particular inside plan that he deploys on cases where they're going to grant cert. What does that mean? For example, if on January 10th the Supreme Court has that conference of these 3 Second Amendment cases, and if on January 10th there are 4 justices that vote to hear each of these 3 Second Amendment cases, which is possible, what will happen is the decision to grant cert will not be made publicly available right then and there or even in a few days thereafter. Why? It's because Chief Justice John Roberts feels strongly about and insists upon, and that's this. He wants every case that's going to be granted cert to be fully vetted after there's an internal grant of cert by the law clerks that work for the Supreme Court justices to figure out whether or not there's some sort of a jurisdictional problem or a defect with the case that could make the case moot. There could be a lack of standing. There could be an issue with cases or controversies. There could be some other issue that makes the case have a curveball to it. And Chief Justice Roberts does not like that. So after there is an internal agreement to hear a case, before the grant of cert is made public and made official, Chief Justice John Roberts sends those cases back where there's going to be cert granted to the law clerks for each of the justices to study in detail whether or not there's a problem, a defect, if you will, with the procedural posture of the case in some way that will cause the court to waste its time and thus lose a slot. Assuming after there's this review of a case where they internally agree to hear cert or grant cert, and there is no problem or defect that is flagged by the law clerks, then the next conference, and this is where the concept of the relist comes in. If, for example, on January 10th, they conference one of these cases and they agree to hear them, they will relist the case publicly. So you will see publicly that a case or these 3 cases have been relisted, which means it will be reconsidered at the next conference. So that's what we, members of the public, will see. But internally, what's going on is there is a furious review of the procedural posture of the cases that they anticipate granting cert on. And then, assuming there's no defect or problem with these cases, at the next conference, they will reaffirm internally that there are still 4 or more justices that want to hear the case. And at that point, they will grant cert formally. And the next day or 2 after that, they will issue their orders list, and on that orders list will be a statement that says that the Supreme Court has granted cert in that case to hear it on the merits, and they will often articulate the particular question presented that they want the parties to answer, whatever that question may be. Okay, now, the only other thing I want to mention, because we're talking about this, sometimes a case can be relisted on multiple occasions. So here's what we don't want to see. We don't want to see a conference scheduled in these cases on January 10th and then a relist to January 17th and then another relist to January 24th and then another relist after that, and so on and so on. And why do I say that? If you ever see a situation where a case, and this is not universally true, but this is something to pay attention to. It's often true, but not always true. If you see a situation where a particular case is relisted and relisted and relisted and relisted and relisted, often what that means is bad news. What that may mean, not always, but often means that the Supreme Court intends to deny cert to that particular case, but one or more justices are unhappy with the decision to deny cert in that case, or they feel they want to make a comment about it, and therefore they take time to write a dissent from the denial of cert, which is basically their own opinion, or they write a statement to go along with the denial of cert to say, we agree with the denial of cert, but we have this statement to make. And because it takes time to write either the dissenting opinion from a denial of cert or a statement that goes along with the denial of state, because it takes time for the justices to write that up and check it, you will often see a relist and a relist and a relist week after week after week after week, because you're buying time for one or more of the justices to write either that dissent from the denial of cert or a statement to go along with the denial of cert. And that, again, takes time. And sometimes they can't get it done in a couple weeks because they want to write something extensively, let's say. So again, bottom line is this. I hope that process helps you understand what goes on inside the U.S. Supreme Court. But the bottom line is, if all you care about is winning for the Second Amendment, here's what we want. We want to see an order in the next couple weeks that says these 3 Second Amendment cases are scheduled to be conferenced or will be conferenced on January 10th, 2025. And then we want to see that case relisted one time, maybe twice at most. And then on or before January 28th, 2025, we better have one or more of these cases granted cert, or we're going to be in trouble. Not catastrophic trouble, but we're not going to be in good shape. I'm just going to call it as I see it. But I got my fingers crossed that things will work out well. So anyway, folks, well, I hope this was not too geeky for you with some of this inside baseball about the Supreme Court. But I did give you some key dates that you need to circle on your calendars and in your cell phones and like. And again, make sure you subscribe to this channel. We're trying to get to 200,000 subscribers. Don't forget to share this video with your friends and colleagues. A lot of people don't get to YouTube. Don't forget, I'm now posting my videos on Rumble for those of you who like Rumble and are not on YouTube. So I'm doing that as well. And make sure you follow me over on X. We have over 20,000 followers on X at 4 Boxes Diner. And I look forward to talking to you all again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.